Hello everyone, we'll make a start. It is 7 o'clock. Good evening, welcome to the meeting this evening of the Audit and Standards Subcommittee hearing panel. Should read from the report in front of us. We've got one report tonight. The purpose of the report is to determine whether or not this panel accepts the findings of the investigation report regarding complaints received against the subject member, Councillor Smith, and what sanction, if any, it determines should be imposed upon the subject member. I think we'll start off, because these are quite unusual, we don't have these very often. We will go around the table, introduce ourselves, which will help the record as well. Starting with Mr. Durham.
Yeah, I'm Jeff Durham, Civic and Member Support Officer for Newcastle Borough Council.
Jeff is not used to speaking into the microphones. Just please use your microphones. For those who are new to the facility, if you push the button in the centre of the microphone, the red light will come on the deck and on the colour if it's working, and you'll be heard for the broadcast as well. But Councillor Burnett.
Hello, I'm Councillor Burnett Fortner, and I represent the Kidsgrove area, and I'm on the Audit Standards hearing panel tonight.
Yes, good evening, everybody. Councillor Mike Stubbs. I'm also a parish and borough councillor for Lyme.
Councillor Mark Holland, chairing the panel tonight, representing Westlands Ward, but I also sit on the Audit Standards Committee.
Good evening, everyone. I'm Anthony Harold. I'm the Director of Legal and Governance here at Newcastle under Lyme Borough Council, and also the Monitoring Officer.
Hi, I'm Chris Murphy. I'm just here in support capacity for action.
I'm Angela Smith.
Thank you very much, everybody. I don't want to go into huge detail. We have got very detailed, independently produced report in front of us. Appendices to that report include comments and statements from both the subject member and others involved in the researching of that report. What I would clarify is that we're here tonight as the principal authority for Beckley, Bolton, Rhine Hill Parish Council. I think I've got the name of the parish right. Many apologies if I'm not. In accordance with local government standards regime, we are responsible for analysing standards complaints in this way, and our monitoring officer and his predecessors were involved in a much earlier stage. I will open up then the report on our agenda, which is, or I should say, declarations of interest first of all. I think we don't have any. If anyone does the declaration of interest, now would be the time to raise it. With that out of the way, item number 3 then is the hearing. I don't intend to move item number 4, which is disclosure of exempt information. But if at any point tonight we are advised by our monitoring officer that we should do so, we may be compelled, we may feel compelled to move that motion. If that happens, both the public and the press, I'm afraid, are excluded from the meeting. But until then, the hearing is taking place in public. I suppose I'll start off then, if I may ask a question. The recommendations on our agenda, and they're common to all of these similar items, are that we need to make a finding. We were invited to determine whether the subject member was subject to the code at the time of the behaviour complained of, and if so, whether the panel can code the findings in the investigation report, which has been submitted, that the behaviour complained amounts to a breach of the code. Now, I think, as my understanding of it, having read the report and the rebuttal to it, my understanding is that the subject member accepts that you were subject to the code of conduct at the time of the behaviour complained about, with the exception that anything that was published on the website, anything that was published on the blog, was ruled out of scope by the independent person who produced the report. Everything else, the answer is yes, you were subject to the code, you're acting on behalf of the parish council or as a parish councillor. And you have not, I don't think, disclaimed or disputed some of the actions and the words that were attributed to you. But what you would say is that, given proper context, that those words and actions did not breach the code. Is that an accurate assessment of your position, Councillor? Please use your microphone, sorry.
Yes, I think in context. Excellent.
Thank you for that. That's helpful. Members on the panel, would you like to ask any questions?
Councillor, I don't want to go through the report verbatim because we've all had time to read the report, but there's one particular section where you remarks about memberships, political organisations. One of your comments is that you don't believe that political parties should be involved in parish politics. Can you expand on that one? Why you believe that and what effect political parties have on parish councils?
I understood that parish councils were non-political. For the simple reason that it was a group of people working together to get something done, but there wasn't the same conflict that you get when political parties are involved and when choices have to be made that are often political.
Okay, and I accept that at face value. I think there is massive value in political parties working in parish councils. From my point of view, Kisgrove, and there's 2 Kisgrove parish councils sitting here, it's a wonderful breeding ground for councillors that wish to go on to borough and then county level to learn their craft. So I disagree with that, and there's definitely nothing legal that says it cannot be. In fact, you would be allowed to be badged if you could. The other thing in that section as well that sort of especially kind of an interest here, when you talk about masonry, why would you bring masonry or any other societies into parish council? I think.
Sorry, those comments were made because under the new code of conduct, members are supposed to declare an interest if they belong to any kind of organisation, any kind of political party. So really the political party bit and the Mason bit was just to emphasise that, you know, these are an interest, should be declared.
Apologies, I'm just getting back in from the back of the room saying that I think people who are here observing having difficulty hearing what Councillor Drakakis-Smith is saying.
You can bring the.
So I don't know if it's a technical problem tonight or I know we've all got different levels of volume in our voices and these, but perhaps you can just repeat what you just said. Yeah.
I think what I just said, if I can repeat that, was that the new code of conduct that the parish council accepted in 2022 states that if people have an interest and they did exemplify, as an example, they stated political parties, and I think Masons were also in that list, the people declare that as an interest.
And I accept that, and we all fill a form in on a yearly basis to update that. But why would that come into a town council meeting? I don't understand why you'd be bringing any work of, you know, for example, the Masons. It's the biggest charity in the United Kingdom. Why would it be used in a derogatory term? I don't understand. Well, the report begs to differ, councillor. That's what I say to that. But that makes me uncomfortable, given the work, especially the staff issue that goes on.
Sorry, I do not recall that I raised it in any derogatory way. It's simply a statement we were discussing the code of conduct, and that was raised that, you know, these things should be included, totally included.
Thank you, Chair.
As a matter of transparency, I guess.
Thank you, Councillor Stubbs. Councillor Bennett-Falkner, do you have anything to add at this stage? So I don't wish to be anticlimactic about this. I know this is a serious meeting and the allegations in front of us are quite serious. I'm satisfied, I think, with your comments, Councillor, that it's the context and the gloss based on your words and actions, which is the point of departure between yourself and the independent reviewer who commissioned the report that's in front of us. The finding of the report is that you did breach the code of conduct, and we are required as a committee, as a subcommittee, to take a view of an independent person The independent person has read this report, our monitoring officer has read this report, and it's been referred to us to look at. In part because you disagree seriously with the findings. I think I understand that. And at the end of the meeting, we will give you an opportunity to sum up and to say anything you would like within reason, within a short space of time, which we will then go away and think about in private, so not in public. But the panel will come to judgment on the things that we've been asked to, which are on our agenda. And it seems to me as though working through the numbers, number one, the subject member was subject to the code. I think there is agreement on that. That's not been challenged. If so, whether the panel concur with the findings in the report, which has been submitted, that the behaviour amounted to a breach of the code. So we have had extensive prior. We've had all of the material that you shared with us and with the authority. We've had all of the comments, the complainants. We've had the very, very detailed report that was produced for us. And we've had a few words of wisdom from our monitoring officer. So I don't think we need to ask any more questions unless councillors would like to examine other parts of the report in more detail. It is all done in writing. And if other councillors don't have any comments to make at this point, I will be very happy to give you. Will 10 minutes suffice, or you speak for a little less long answer?
I'll see how we go.
In that case, it will blink at you to tell you you're speaking for too long. Don't worry, you're not. The time limit is set for councillors in our ordinary meetings, where we very rarely shut up in time. In that case, thank you very much then, councillors on panel. Thank you for your forbearance. If you'd like to make a statement now, please do, and we're happy to hear it.
I'm attending this hearing because it's important to know what it is I'm being accused of. The monitoring officer in June 2023 asked the complainants to provide him with the specifics, that is, the evidence to support their allegations. Without it, he stated he could not proceed. It has taken 2 years and a new monitoring officer to arrive at this juncture. 2024 is a different country, it seems. If evidence was submitted, then I have not seen it. I have looked at the allegations against me, and I do not recognise myself or my behaviour in any of them. From the first meeting I attended, when I opened the door, someone shouted at me to get out. That set the tone for the next 2 years, where the effort and hard work of this council seemed to me to be persuading me to resign. Placed in a similar position, many people would have bailed out long before this. I have remained to see how authority deals with truth and justice, and because residents have asked me to. I've been accused of bullying, harassment, intimidation, and all the other words which meet the criteria for a breach of the code of conduct. I'm not a bully, I'm not a liar, I do not intimidate, or anything else that I'm being accused of. I am direct, and I'm trying to be clear in what I am saying, especially to authority. Speaking truth to power is never easy and seemingly dangerous if there is anything to hide. However, this is not the same and should not be confused with bullying, harassment, and intimidation. I have not brought the parish council into disrepute. In fact, I have tried to prevent that from happening, which is why I have not brought complaints against it or my fellow councillors. Any disputes or clash of views, I thought, could be dealt with internally and within the parish council. Except in this parish council, there is no rule or procedure to deal with any internal disputes, only referral straight to the monitoring officer for consideration. Clearly, the allegations were not considered to justify a complaint, since they remained with the monitoring officer for the past 2 years. It was my understanding that such complaints had to be dealt with as soon as possible, or at least within a year. The monitoring officer suggested that making a complaint would be expensive and counterproductive. Also, if evidence was not forthcoming, then a case could not be brought. If evidence was provided, then I have not seen it, and this might raise issues of fairness, even impartiality regarding this hearing. I have refuted all the allegations made against me by the 3 councillors and those made against me by the Beckley resident. The evidence of my rebuttals of these complaints are contained in a box which I would have brought as far as not to. It's all that large. It is the complainants and the chair who have insisted on taking the matter further. This is why we are here tonight, and it is costing residents of Bethley Parish £23,000 and counting. The solicitor in her report stated that she had not focused on the individual complaints, but instead she had chosen the clearest examples rather than a decision in relation to each complaint. In using this methodology, it seems to me she's focused and relied heavily on 15 phrases which have been selected by the clerk from around 1,200 pages. That would be around 2%. The phrases used have been removed from their context, and the interest of this hearing, context is everything. Had the minutes and the emails been scrutinised, it would have been noted that what I had written had been misunderstood, misinterpreted, and in my view, and as the author, even misused. There were certainly a lot of emails, and I did not generate them all, which have been suggested. It takes two to prolong or widen a discussion, or to have an exchange of view, and to come to a compromise. In Bethley, there seems to be only one, and that seemed to be that of the chair, supported by the clerk. At any one time, there were up to 6 councillors firing emails at me, also the clerk and chair, to whom I was obliged to respond. I was damned if I did, and damned if I didn't, it seems. The context, if it had been included, would show that these phrases were part of an explanation and came with all kinds of caveats and were tempered by words such as might, could, if, perhaps, etc. Unfortunately, these phrases have been divorced from these words, which then presents them as bald statements, which they were not. To remove them from their context would be a disservice and a misinterpretation of their meaning. For example, if minutes of meeting were not entirely accurate, and if they had been voted by members as being accurate when they were not, then they would indeed, and in my view, not be worth the paper they were written on. In pointing this out to the clerk, I was trying to prevent the council from being brought into disrepute. In asking questions and raising issues, I am doing my duty as a councillor. I write reports, and I've written about 22. I read the information papers and policy documents, and especially the minutes. The solicitor claims that it was not her brief from the Borough Council to determine whether the minutes were or weren't accurately recorded. And yet this hearing rests mainly on that issue. Given that the minutes are produced each month they raise issues, and therefore comments from me, especially where I have been mentioned in a derogatory way. Minutes should be objective and impartial. In pointing this out, I have been ostracised when the objective has been to try to introduce amendments and corrections which have made them accurate. This endeavour and intent is also evidenced by the little box. The sticking points also appears to be attached to giving information to residents. I have started a newsletter and I keep an independent blog in order to keep Ryder residents informed. The parish council is an administration and a bureaucracy. It generates information that is not the council's property, but public property, which needs to be distributed and made known to its public. On this point, there's a clear clash between my view and that of this parish council, which could have been reconciled in-house. It's flashing.
So please carry on. Yes.
I drew up a list of 10 contentious issues. Of these, eight were contentious because they were about me producing and distributing information and or placing information into the public domain. I am here today charged with disrupting my fellow councillors, possibly owing to the occasional regretful use of phrase from time to time, born out of a frustration. However, as per the council's code of conduct, disrespectful behaviour can take many forms. For example, any behaviour that a reasonable person would think would influence the willingness of the councillor to speak up because they expect the encounter would be unpleasant is one definition of disrespectful. Every time I raised a question or an issue, eyes were rolled, glances were shared, and reference to time taken was continually made. Standing alone in a room with a hostile atmosphere month after month is hardly the action of a bully. Bullying may be characterised as offensive, insulting, or humiliating behaviour that can make a person feel vulnerable, upset, or undermined. All things that I am accused of today. I have been subjected to collective offences, whether by inference or directly given, such as the label given and shared amongst my colleagues, Councillor Dracula Smith, for instance, or made to feel that I did not fit in because it was interpreted by one councillor that I was upsetting the apple cart. I wonder which box in the integrity and respect criteria of the Code of Conduct this coercive behaviour would be ticking. Unfortunately, much of this could have been avoided and certainly reconciled with discussion, not argument, patience, not impatience. My questions and any attempts to assure accuracy or comments on issues that were raised in meetings were interpreted as nitpicking, digging, and editing, as derogatory and criticism of the council. And this might have been because my questions revealed many omissions and lack of written procedure which councillors need in order to operate openly, transparently, and effectively. I was therefore attempting to do my duty. I did not harass the clerk or bully him or do anything else that has been alleged. Although it was resolved that the style of the minutes be changed so that they would be more objective, impartial, and less pointed at one individual, this did not happen. This behaviour, therefore, could also be brought into question. Each month, a new set of minutes were produced in the style adopted since May 2022, when I joined the council. Since I objected to this style, failure to change it could be construed as a form of bullying, which was guaranteed to bring a response from me that the clerk knew would be direct. That behaviour could also be interpreted as harassment as an attempt to build up a case of repetition. The evidence would suggest this. The clerk had a long history and experience of council and political work. He reveals in documents that I have only recently seen that he was a parliamentary candidate, a lifelong member of a political party, a councillor, and a clerk elsewhere. With all this experience, I would have expected that he would have known how to maintain a balance within the council, how to ensure that individuals were not isolated and targeted, bullied and intimidated, and to ensure that there were procedures in place to deal with any such behaviour. This would be the remit, I would imagine, of any clerk. It has, however, taken 2 years and a week before retirement for the clerk to make a complaint against me, and another 3 months after retirement to provide any evidence such as it is. I am therefore sorry that the first 3 months of retirement had to be spent in this way. Unfortunately, the complaints have dictated how I spend my time too. In summary, I would like to say, and although I say it last, it is not least. I did not envisage that in trying to be a good councillor, that I would be upsetting my fellow councillors, and that I would be spending most of my time firefighting. So for any intentional upset, because it was never intentional, I would apologise. It is unfortunate that there has been what the former MO called a clash of personalities. I am not known as an attacker, but I will certainly defend. To avert a clash, however, there has to be compromise. Mediation was offered to the chair in December 2022 as a positive, even cheaper way forward, but the chair did not pursue that. I also offered to sit down with the club and talk things through. I did not receive a response. Perhaps I also held the view wrongly that a parish council was a tier of government and governance. In this, I have had expectations that were not aligned to the practices or view of this council. Perhaps my expectations for accuracy in minutes and other council business were also too high. So for that, I also apologise. I have a high regard for truth and honesty, fairness, justice, and objectivity. I can say in all honesty and in good faith, backed by the context on my absent box, that I have stepped to those principles. So I'm not going to apologise for that. As the odd one out, I was expected to compromise and fit in regardless. When I came to this council, I did not expect any concessions, but I did come with the expectation of being treated as an equal. I apologise for making that assumption. As per the local authority's code of conduct, I have been given a democratic mandate to represent the public interest and inform them of the actions of the council. As I am sure this hearing is aware, the code of conduct clearly states that councillors are expected to express, challenge, criticise and disagree with the views, opinions and policy. Therefore, as a council, I have performed my duties within the remit of this code. Thank you for your time.
Very much, Councillor Smith. I will invite our legal officer to advise us whether there is anything further that we should or is necessary for us to transact in public before we withdraw.
I don't think there is actually really anything else we need to add. I mean, the report, you've clearly got the report, and within that there are various options there that you can consider, and there's obviously a step process, 1 to 4. What I would just say, and I will just say this for public benefit as well, is that the way that it works, the system works in relation to parish councils, is that if, as members of this panel, or whichever decision this panel makes this evening, will, if there are recommendations, those will be recommendations to the Betley, Barnsley and Rhinehill Parish Council to take any action that they may deem appropriate in the event that that you as councillors find that the case is made out as per the solicitor's report. So in terms of evidence, you've been provided with all the evidence that I have seen. You've also had the opportunity of obviously hearing directly from the subject member, Councillor Smith, and she's been invited to ask any questions. If there was any further, I would just clarify the statement that's been made. There is an opportunity. I'm just presuming that you're satisfied that you've made your submissions in full today.
Well, very welcome to answer that. And please use your microphone and you also would like to. If you would like to, but only with permission with the subject matter, supporting the live.
Just wanted to draw attention to the fact that at some point throughout this episode, and all of that, there was a suggestion by one of the councillors in the chair for Angela to make an apology. Yeah, I'm told, well, it's documented that Angela did make such an apology. Okay, and we're told by the independent legal representative that that apology was more than sufficient. It wasn't accepted. Yeah, we could have avoided this if that apology had been taken at face value and they worked together to get to a solution before we ended up in this situation today. Yeah, as I say, the report was independent and they said the apology was more than enough. I believe that the clerk himself wanted to write his own apology to be signed by Angela, and that she wasn't prepared to do because that would lead to her own incrimination by admitting things she was being accused of. So yeah, in summary, this could have been avoided. Yeah, if people had worked together to come to a solution before we got here today.
Thank you for that contribution. I'm sure those comments will be taken on board by the chair and the panel. I would just remind the panel that there are actually 5 complainants in this matter. Yeah.
Yes, thank you very much for raising that. I know that the solicitor's report in front of us does include a description of that apology and its sufficiency, and we will of course bear that in mind. Councillor Trehart.
It's just with regard to what is regarded as evidence. A lot of the evidence I saw was actually circumstantial or hearsay. People were talking about feelings, they were talking about something, leaflets that they haven't even read, they were making an opinion on, or taking a stand on. I understand that the solicitor adjudicating did not look at everything. She certainly didn't look at the minutes. And as I said in my statement, that they were quite crucial to events because a lot of my comments were about the accuracy and the way the minutes were sometimes phrased, particularly or especially with regards to myself. I found some of the phrases that the clerk used were derogatory and that I was made to look incompetent with that thing, which I found somewhat offensive. And there's nothing I could do to change that, even if it was just a word. Clerk refused to alter that to make those minutes and that minute correct. So I was not trying to change the circumstance. I was trying to say, you know, this is how it happened, and this is how it would be more correct, or would be correct, and I would agree with it. But as it stood, I did not, and I have a right to say that. I think most of the minutes or minutes referred to me were written in such a way that it was impossible, or it would take more nights to adjust them to make them accurate. Trying to make an amendment was difficult, and when I did, I was outvoted. One person standing amongst 11 is pretty ineligible. With regards to the 5 complainants, the adjudicating solicitor said, more or less said the same thing. Now, was that collaboration or was that corroboration? The chair, in a letter to the monitoring officer, mentioned the word collaboration. And given the evidence and given all the emails that I actually did read, it's looked to me like collaboration. And I would take that seriously.
Thank you for your further comments. Obviously, I don't think it's for us now to go into each and every one of those points. But what I would add is, as appendix 2 to the report, which is available, and as members you do have in front of you, there is a lengthy what is termed a rebuttal on your behalf, Councillor Smith, and it goes from page 49 through to page 80. So quite considerable amount of pages there of what you regard as a rebuttal, and obviously that has been being presented to the panel, and obviously will be further considered in the deliberations. Thank you.
Thank you to our legal officer for that. Thank you, Councillor, for drawing our attention to that aspect of the report. Quite rightly, some detail is gone into, and also what you said tonight is supplement to the advice you gave. It being our officer's advice that we don't need to consider anything further, I'd like to thank everyone for your time this evening. Thanks to you, thanks to members of the public in the gallery. This panel's findings and its comments will take the form of a letter addressed to the parish council, but we will also write to the subject member. And if there is anything arising out of this process that we feel needs to be considered more generally by audit and standards of this council, we may well write to the chair of the audit committee if we have any comments about process or procedure. I think that concludes the hearing tonight. Thank you very much, everybody, for attending. Good night.
Thank you.